On December 6, 2023, bullhornbetty filed a motion to dismiss first amended counterclaims document with the court. This is the case in which BHB is suing Queen B and Queen B is countersuing BHB. Today we are going to take a look at BHB's new filing. I am not a lawyer and I do not claim to be one. I will be showing and reading the court documents for your viewing pleasure. Motion to dismiss first amended counterclaims comes now. Counter-defendant, bullhornbetty, pro se, and respectfully moves the court for an order to dismiss counterplaintiffs' first amended counterclaims according to Illinois Rule 735 ILCS 5/2-615 filed herein, for the reasons set forth below. Background. On or about October 18, 2023, bullhornbetty, BHB, served Queen B, QB, with an amended complaint alleging defamation, tortious interference with prospective economic advantage, intentional infliction of emotional distress, civil conspiracy and concert of action, negligence and unjust enrichment. QB caused damages to BHB for over a year. BHB did nothing to justify this outrageous and detrimental campaign of bullying, stalking, harassment, and other damages that QB knowingly inflicted on BHB for no other purpose than to cause damage to BHB for monetary and other gains and/or benefits realized by QB. BHB has alleged, among other issues, that QB has conspired and communicated with others through private chats, such as Discord and other similar sites, to elicit help with QB's campaign of harassment, cyber-stalking, bullying, and intimidation to receive financial compensation, to damage BHB personally, professionally, financially, and to remove BHB from the YouTube platform. Moreover, it is upon information and belief that QB is still engaging in this type of assault against BHB as this action is being litigated. QB has elicited help from others to falsely copyright strike BHB's YouTube channel, which has resulted in BHB being restricted from uploading videos or running live broadcast streams for 7 days. Although BHB's account was not terminated, banned, or suspended, it did not stop QB from campaigning to remove BHB from BHB's backup channel. QB is willfully, maliciously, and with a forethought causing damage to BHB with no regard for the current court proceedings. The individual that struck BHB's channel is associated with the defendant and/or associates of the defendant that the defendant has elicited help from in the past. On or about November 2, 2023, defendant QB filed a motion to dismiss the amended complaint citing conflicting law which is at issue in this matter. On or about November 8, 2023, defendant filed first amended counterclaims. The counterclaims are littered with incoherent chatter about how QB loathes BHB's career choices, business practices, and BHB's associates, but fail to indicate what specifically BHB has done to QB to cause damage, how those actions BHB allegedly committed have damaged QB personally, professionally, or financially. Somehow the nexus between the background statements alleged and the claims raised are skewed, confusing, and lacking factual information upon which a response can be formulated. BHB alleges QB has failed to state a cause of action on both counts, needs pleadings to be made more defined and certain, failed to attach any supporting documents to the counterclaims, contains irrelevant information that should be stricken, and failed to add necessary parties to the claim among other deficiencies outlined in more detail below. Legal standard. According to Rule ILCS 5/2-615, there are several grounds to challenge QB's counterclaims. Barbara Coleman v. AK Midwest Insurance Company, 236 IL App, 3D, 1065, 1068-69, IL App, CT, 1992. 1. A motion to dismiss under Section 2-615 attacks only the legal sufficiency of the complaint. A basic premise of Section 2-615 motion is that it accepts, for purposes of the motion, that all well-pled facts in the complaint are true. 2. There are 6 bases for attacking pleadings under Section 2-615. 1. That the pleading be made more definite and certain. 2. That designated immaterial matter be stricken. 3. That necessary parties be added or misjoined parties be dismissed. 4. That the pleading fails to allege essential elements in the cause of action. 5. That the pleadings fail to state a claim upon which relief may be granted, and 6. That the pleadings entitle the moving party to judgment. Il Reverend Stat 1991, Chapter 110, Paragraph 2-615, see Lasusa Heinrich, pretrial motions under Sections 2-615 2-619, 3 CBA Rec. 32, November 1989. None of these bases require the movant to provide any factual matter to the court to prevail. The question presented by a motion to dismiss under Section 2-615 is whether sufficient facts are contained in the pleadings which, if proved, would entitle the plaintiff to relief. Orbitis, 143 ill. 2d at 475, 575 n.e.2d at 555. Here, QB cannot be successful on the counterclaims due to QB's deficiencies contained therein, rendering the entire document legally insufficient and devoid of the necessary elements, among other legal challenges and deficiencies. The pleading be made more definite and certain. Failed to state a cause of action. Common for all counts under this section. In reviewing the sufficiency of a complaint, we accept as true all well-pleaded facts and all reasonable inferences that may be drawn from those facts. Ferguson v. City of Chicago, 213 ill. 2d 94, 96-97, 2004. We also construe the allegations in the complaint in the light most favorable to the plaintiff. King v. First Capital Financial Services Corporation, 215 ill. 2d1, 11-12, 2005. Thus, a cause of action should not be dismissed under Section 2-615 unless it is apparent that no set of facts can be proved that would entitle the plaintiff to recovery. Cannell v. Topinka, 212 ill. 2d 311, 318, 2004. The purpose of 735 ILCS 5/2-615 is to test the legal sufficiency of the complaint. The critical inquiry is whether the allegations of the complaint, when construed in the light most favorable to QB, are sufficient to establish a cause of action upon which relief may be granted. BHB contends there are substantial issues with the counterclaims which render the pleading devoid of a cause of action for each of the counts alleged. Also, QB must allege facts, rather than conclusions, to support a cause of action. Darling v. Charleston Community Memorial Hospital, 4th DST, 1964, 50 LAP.2d, 253, 310, 200N.E.2d, 149, Van Dekkerkov v. City of Heron, 1972, 51 ill. 2d, 374, 282N.E.2d, 723. Count 1. Abuse of process. According to QB's counterclaims served upon BHB on or about November 8, 2023, it is alleged that BHB is abusing the process of this honorable court. However, QB fails to allege with clear and convincing language how BHB has abused the process of this court in this matter. QB fails to meet the clear and specific elements necessary to state a cause of action upon which relief may be granted concerning the abuse of process claimed by QB. Based on QB's counterclaims, QB alleges that BHB, on a previous occasion, allegedly abused the process in another court at some unclear and uncertain date, time, and location. QB fails to provide any particularity of how that case affects QB or QB's allegations therein. It is not clear or concise. QB's claim for abuse of process is based on BHB's alleged filing of an action in another case at some other location and time. There was no reference to this other action except for an unsubstantiated website with no apparent connection with QB's claims, and there were no supporting documents attached to the counterclaims as a reference point for BHB to review and formulate a response. Moreover, appears QB is rendering legal conclusions as opposed to alleging facts. QB alleges because BHB has abused the process in the past and that BHB must be doing it now, and that notion is insufficient to support QB's cause of action for the abuse of process count. QB alleges that because QB believes that BHB has abused the process sometime in the past, it automatically provides an avenue for QB to claim abuse of process without alleging the necessary elements to support a cause of action or claim therein, which is the subject of this lawsuit. An action for abuse of process provides recourse when a defendant misuses or misapplies the legal process to accomplish some objective other than something within the legitimate scope of the process. Commerce Bank, NAV, Plotkin, 255 IL App, 3D 870, 872, 1994. To state a claim for abuse of process, a plaintiff must allege facts showing 1. The existence of an ulterior purpose or motive, and 2. Some act in the use of the legal process that is not proper in the regular prosecution of the proceedings. Withall vs. Capital Federal Savings of America, 155 IL App, 3D 537, 544, 1987. QB has failed to state 1. What ulterior purpose or motive BHB has in this matter and 2. QB has failed to establish or show which act or acts BHB has used in this legal process which is not proper in the regular prosecution of the proceedings. Emphasis added. QB must meet both elements to state a cause of action upon which relief can be sought because between elements 1 and 2 is and. If it was or QB would only need to meet one of the elements necessary to state a cause of action upon which relief may be sought and QB has not met either element. QB has basically only alleged that BHB filed legal proceedings for malevolent purposes sometime in the past. That is not sufficient. In fact, Illinois courts have generally taken a very restrictive view of the tort of abuse of process. ID. The cause of action for abuse of process is a narrow one, and its elements are strictly construed because it is not a favored cause of action under Illinois law. Kumar v. Bornstein, 354 IL App, 3D 159, 166, 2004. Plaintiff failed to state a cause of action for abuse of process, and the trial court did not err when it dismissed this claim. Emphasis added. It is unclear to BHB what the cause of action upon which relief may be sought and or granted. Moreover, lacking the necessary information bars BHB from being able to provide an answer or identify any potential affirmative defenses BHB may have or assert. Therefore, QB has not met the necessary elements to maintain this count, abuse of process, for failure to state a cause of action, and for the pleadings to be made more definite and certain. Count 2. Defamation per se. To state a defamation claim, a plaintiff must allege facts showing that 1. The defendant made a false statement about the plaintiff. 2. The defendant made an unprivileged publication of that statement to a third party, and 3. The publication caused damages. Illinois considers the following 5 categories of statements as defamatory per se. 1. Words that impute a person has committed a crime. 2. Words that impute a person is infected with a loathsome communicable disease. 3. Words that impute a person is unable to perform or lacks integrity in performing her or his employment duties. 4. Words that impute a person lacks ability or otherwise prejudices that person in her or his profession, and 5. Words that impute a person has engaged in adultery or fornication. Green v. Rogers, 234 IL 2D 478, 491-92, 917 N.E.2D 450, 459, 2009. Although a complaint for defamation per se need not set forth the allegedly defamatory words in haec verba, the substance of the statement must be pled with sufficient precision and particularity so as to permit initial judicial review of its defamatory content. Precision and particularity are also necessary so that BHB may properly formulate an answer and identify any potential affirmative defenses. QB contends that BHB made false statements about QB on or about March 2023. However, QB does not plead those facts with particularity. There are 3 elements QB must meet to state a cause of action for defamation per se. QB has failed to meet all the elements necessary to state a cause of action upon which relief may be sought or granted or for BHB to formulate a response or to ascertain potential affirmative defenses BHB may have or assert. For QB to maintain this cause of action QB shall meet certain elements to support that cause of action which QB failed to do for the grounds stated as follows. 1. QB contends BHB made a false statement about QB on or about March 2023 but fails to state with particularity how those statements were false. QB failed to attach any supporting documentation to the counterclaims for BHB to reference or in support of these elements, which is the subject of this lawsuit. 2. QB must assert that the communications made by BHB were privileged publications of those statements to a third party. QB has made no such assertion within the 4 corners of the counterclaims and has made no reference whatsoever that any statement allegedly made by BHB were privileged in nature or the nature surrounding the information, and QB has failed to attach any supporting documents to the counterclaims for BHB to reference or in support of this element. 3. QB must assert the publication caused damages and what those damages are with particularity. There was no mention of the damage or damages which has caused harm and or damage to QB, financially, professionally, and or personally. The counterclaims make no mention of any damage QB sustained by the alleged actions of BHB. QB has alleged that some information contained within the counterclaims is upon QB's information and belief. Unlike the facts relating to the allegedly defamatory statements themselves, the facts informing QB's belief will always be within QB's direct knowledge and therefore fully capable of being pled with the requisite precision and particularity. It is unclear to BHB what the cause of action upon which relief may be sought and/or granted. Moreover, lacking the necessary information bars BHB from being able to provide an answer or identify any potential affirmative defenses BHB may have or assert. Therefore, QB has not met the necessary elements to maintain this count, defamation per se, for failure to state a cause of action, and for the pleadings to be made more definite and certain. Failure to attach required documents to the counterclaims. All counts. QB alleges BHB has 1. Abused the process of this court and made defaming remarks about QB either. 2. Per se, QB failed to state a cause of action or actions on both counts contained in QB's counterclaims. QB is required to attach to the counterclaims any written document upon which the claim is based, and these documents are to be treated as part of the complaint itself. Hess v. Lloyd, 2012 IL App, 5th, 090059. QB has failed to allege any claim with specificity or particularity and further failed to attach any documents that would assist BHB in understanding what QB's claims are. Currently, there appear to be multiple claims with multiple individuals for a variety of reasons as listed in QB's counterclaims, but it is not clear how BHB's alleged career choices, business practice, and/or associates in which BHB allegedly confers with have anything to do with QB or how the alleged actions of BHB's career choices, business practices and/or associates which BHB allegedly confers with have directly caused harm to QB. QB states BHB has abused the process of this court, but failed to allege how BHB has abused the process of this court, and QB has failed to attach any supporting documents related to this claim barring BHB from rendering a response or allowing BHB to assert potential affirmative defenses. QB states BHB has made statements of fact that were allegedly false about QB but failed to allege the location of the said statement defaming QB or providing any concise information with specificity or particularity other than the alleged assertion that said acts happened on or about March 2023. There is no specificity in the claims asserted by QB. Due to those failures, deficiencies, and legal challenges, BHB is unable to render a response or assert any potential affirmative defenses until such deficiencies are clarified. There is no supporting information on which BHB can rely upon to formulate a response, an answer, or to assert potential affirmative defenses, and therefore QB's counterclaims are legally insufficient. Due to the failures of QB to sufficiently plead the facts of this case and to include supporting documentation, BHB is unable to render a response to said counterclaims, or assert any potential defenses or remedies available to BHB. It is unclear to BHB what the cause of action QB has without supporting documentation attached to the counterclaims and upon which relief may be sought and/or granted. Moreover, lacking the necessary information bars BHB from being able to provide an answer or identify any potential affirmative defenses BHB may have or assert. Therefore, QB has not attached the necessary supporting evidence to maintain any of the two counts alleged by QB concerning abuse of process and defamation per se, rendering legal conclusions rather than alleging facts. Counterclaims contain irrelevant and immaterial information that should be stricken. All counts, as stated in the paragraphs above, QB has included irrelevant and immaterial information that should be stricken. QB has a clear disdain for BHB and the reason we are before this court. Among the issues raised by QB states somehow BHB's conduct in the course of BHB's career somehow affects QB or QB's daily life so much so that QB is left with no other choice, but that is not the case. QB chooses to conduct herself in this fashion. QB has not alleged one fact to support any alleged contact between QB and BHB at any time before the initiation of the lawsuit, but littered the counterclaims immaterial and irrelevant insolent talk that fails to support any of the allegations asserted by QB in the two counts that were presented in the counterclaims. A pleader must allege facts, rather than conclusions, to support a cause of action. Darling v. Charleston Community Memorial Hospital, 4th DST, 1964, 50 LAP.2D, 253, 310, 200N.E.2d 149, Van Dekkerkov vs. City of Heron, 1972, 51 IL 2d 374, 282N.E.2d 723. If a litigant insists on obscuring his claim with irrelevant and inappropriate allegations, the trial court may simply disregard the improper allegations as surplusage. 27 IL App.3d 331, 334, 326N.E.2d 466, 467. BHB affirms the statements made in QB's counterclaims that QB has verified as true and correct except as to matters therein stated to be on information and belief, are irrelevant and immaterial to the claims asserted by QB in this action. The statements rendered and the claims alleged do not provide enough of a factual basis to state a cause of action and in no way support either of the counts alleged in the counterclaims and are therefore rendered irrelevant and immaterial to the matter at issue and make no connection with QB's alleged claims and/or damages, which is the subject of this lawsuit. BHB contends that all the information contained therein is irrelevant and immaterial to the claims raised by QB and therefore should be stricken and/or removed in its entirety. It is unclear to BHB the who, what, when, where, and how because the pleading is filled with an overwhelming amount of irrelevant and immaterial language. It clouds what facts QB is asserting, what the cause of action is, and upon which relief may be sought and/or granted. Moreover, lacking the necessary information bars BHB from being able to provide an answer or identify any potential affirmative defenses BHB may have or assert. Therefore, QB has failed to allege facts necessary for BHB to formulate a response due to the amount of irrelevant and immaterial language contained therein and failed to attach the necessary supporting evidence to maintain any of the two counts alleged by QB concerning abuse of process and defamation per se, rendering legal conclusions rather than alleging facts. Failure to add necessary parties to counterclaims, all counts. The proper remedy for misjoiner or failure to join a necessary party or parties is to dismiss the improper party or to order the missing party added. Irreverent Stat 1975, Chapter 110, Paragraph 26, see Hitchcock v. Reynolds, 3D DST 1935, 278 IL App. 559, 563. Horwath v. Parker, 72 IL App. 3D 128, 134, IL App. CT 1979. QB has re-alleged each of the foregoing paragraphs on each of the two counts listed and situated within the four corners of QB's counterclaims, which contains sections identifying several individuals in addition to BHB and incorporated therein and located under BHB's awareness of the law section of the counterclaims, which QB appears to allege these additional individuals are some sort of co-defendants. It is unclear and fails to state with specificity or particularity. It indicates among other issues that BHB's actions mirror JLR. QB states JLR recently sued 3 individuals in Ohio for defamation for referring to him as a stalker, doxer, sick, scammer, and not searching for missing people. QB alleged further defaming information about JLR and providing a statement of fact into the court record that is irrelevant and immaterial assertions that Riches has been barred from filing actions in some unknown amount of courts. BHB has no idea or information to rely on related to how this is relevant or material to the matter at issue but appears to be including and incorporating therein a co-defendant. Still, QB has failed to include JLR on the counterclaims and has failed to serve this action upon JLR, thereby failing to include all necessary parties to QB's action, thereby not affording JLR a right to defend himself in this action where QB has raised issue with JLR. QB re-alleged each of the foregoing paragraphs and incorporates those allegations into each one of the counts. Therefore QB failed to incorporate JLR in this action in violation of Illinois law. QB alleges as fact, in late March 2023, BHB participated in a discussion with redacted name, who uses the handle Dolly Vision, Dolly, and redacted name, who uses the handle Molly Go Lightly, Sick, MGL. Although the sentence is incomplete, it is referencing some sort of live stream. All 3 individuals, BHB, Dolly, and MGL, were allegedly discussing QB in a defaming light, but QB again fails to include these alleged co-defendants or reference with particularity which live stream QB is alleging. BHB has no information to rely on related to how QB's allegations are relevant to the matter at issue but appears to be including and incorporating therein multiple co-defendants. Still, QB has failed to include Dolly or MGL on the counterclaims and has failed to serve this action upon either Dolly or MGL, thereby failing to include all necessary parties to QB's action, thereby not affording Dolly or MGL a right to defend themselves in this action where QB has raised an issue with JLR, and now Dolly, and MGL. QB re-alleged each of the foregoing paragraphs and incorporates those allegations into each one of the counts, therefore QB failed to incorporate JLR, Dolly, and/or MLG in this action in violation of Illinois law. However, it is well established in Illinois law that in any event, the non-joinder of the parties is not grounds for dismissal of the complaint unless a reasonable opportunity is provided to add the parties. It is unclear to BHB who specifically QB is suing and for what purpose, and there is no supporting documentation attached to the counterclaims and upon which relief may be sought and/or granted. Moreover, lacking the necessary information bars BHB from being able to provide an answer or identify any potential affirmative defenses BHB may have or assert. Therefore, QB has not included all necessary parties to this action. Conclusion: QB has failed to state any cause of action for both counts. The counterclaims were unclear and not concise, and no nexus exists between the statements of facts alleged and the claims asserted. There was no supporting documentation to assist in clarifying the issues raised, and QB failed to include the additional co-defendants QB raised in the counterclaims. As such, the pleading needs to be more definite and certain, designated immaterial matters be stricken, necessary parties be added, or misjoined parties be dismissed. Pleading fails to allege essential elements in the cause of action, and pleading fails to state any claims upon which relief may be granted. The motion to dismiss counterclaims shall not be misconstrued as a responsive pleading. BHB is merely raising legal issues surrounding the legal sufficiency of QB's counterclaims. Wherefore, counter-defendant, bullhornbetty requests this court to grant this motion to dismiss without prejudice for the reasons set forth herein. Respectfully submitted. By BHB, aka bullhornbetty. Pro se plaintiff. Certificate of service. Undersigned certifies and states that on December 6, 2023, plaintiff caused the foregoing document to be filed using the Odyssey e-filing system. That same plaintiff causes a copy of the same to be served as indicated below. Queen Bee's lawyer. Okay, there you have it. Again, I am not a lawyer and I do not claim to be one. In my opinion, BHB is complaining in this document that QB is not suing her friends. With friends like BHB, who the heck needs enemies? Also, in my opinion, BHB did not even title this document properly. The title of the document is Motion to Dismiss First Amended Counterclaims. In my opinion, it should be First Amendment, not amended. But that is not the only thing that is wrong with this document. I was under the impression BHB was supposed to file a response to the counterclaim, and this is not a response in my opinion. BHB is arguing in this document not providing a response to the counterclaim. BHB also added that QB is associated with the person that struck her main channel and has elicited help from her in the past. In my opinion, this is false. BHB did a live stream on YouTube and stated that JLR was behind her main channel getting suspended. There is so much more that is wrong with this filing, but I will leave it at that. What are your thoughts? Let me know in the comment section. Please smash the like button, comment and subscribe. Thank you to my members. Your support means the world to me. I will see you next time.